stand by while NCLA cuts through the noise to signal abuse of administrative power. This is Administrative Static with Mark Chenoweth and John Vecchione.
Welcome to Administrative Static. I'll be joined by Mark Chenoweth, but right now I'm very happy to welcome our colleague Sheng Li to the program to talk about an unusual win that Sheng and New Civil Liberties had in our Polyweave case. Sheng, welcome to the program.
Hi, thank you, John.
So I called this unusual. Why don't you give our listeners a little bit of idea what was the administrative agency doing to our client and what happened?
Well, this is really gives a lot of insight into the Kafkaesque world of administrative enforcement. And just to give a little background, what happened was, and it goes back many decades, Polyweave is a company that makes packaging for explosive material, and that's used in transportation. It's regulated by the Department of Transportation, and which has all kinds of regulations you have to jump through. And in the 1990s, Polyweave said, well, we have this two-layer type of packaging. Ask the department, hey, what is the testing requirement? Do we have to test this every 12 months or every 24 months? And someone at the department said every 24 months. Fast forward 20 or so years, the department comes back and says, actually, it was every 12th month, and now you owe us money. And put an enforcement action against Polyweave.
It's like
and not only that,
it sounds like Flounder in you blanked up. You trusted us.
Exactly. You were wrong to rely on this other employee 20 or so months ago. So now you owe us money.
Right.
And after after it was 2016 when they brought the charges, but it wasn't until 2021, more than 5 years later, that the charges were finally resolved and Polyweave was hit with a civil penalty order that was issued by the agency's chief safety officer. At that point, we go ahead.
How much was the fine?
It was for $14,000, which it may not sound as much, but Polyweave is a small company. It's got 8 employees, so it's actually a sizable dent for a company of its size.
And just because you mentioned the word explosive, nothing happened, right? Nobody got hurt.
No, nobody got hurt. In fact, the agency investigated people that were using Polyweave's product and said everything they were doing is fine. And under the rules, if you put your product in a defective bag, you're supposed to be in trouble too. But those guys were okay, but Polyweave wasn't. So that was an inconsistency that we tried to tease out. But we didn't get there. We brought an appeal of the agency's order before the Sixth Circuit Court of Appeals, and we raised a number of arguments, including that the statute actually says a violation has to be knowing before a civil penalty can be issued, and this violation can't possibly have been knowing because they were relying on something the agency told them. But you can't knowingly violate the law by following what the agency told you.
Let's put a pin on that and see what they say next. But yeah, I would hope that would be the case.
Yeah. We also brought a number of due process claims, including that Polyweave was denied its jury rights. And finally, we brought an appointments claim under this case called Free Enterprise a few years back, which said an agency adjudicator, the final agent adjudicator, can't be protected from removal by the president, which means he can't. Otherwise, the adjudicator would not be politically accountable and can go off the reservation. And here, the chief safety officer who issued the decision against Polyweave is a career senior executive service officer who enjoys the civil service protection regime and therefore can't be terminated or removed by the president or any other politically accountable person. So we said, look, this guy's not properly appointed, not appointed according to the Constitution. And funny thing is, right before the agency was supposed to file their responsive brief in reply to our challenge, the agency kind of said, hey, we actually agree he was improperly appointed, but not for the reason you alleged. Apparently, the agency uncovered supposedly for the first time that this guy, the chief safety officer, was never appointed by the department head or the president in the first place. And under a Supreme Court decision from 2017,
Lucia,
the
right?
Supreme Court said, Lucia v. SEC is Ray's a beloved, has a beloved history with our organization. But under that decision, an agency adjudicator has to be at least appointed correctly. Even, setting aside the removal question, he must be appointed correctly, meaning either the president or the department head, that is Pete Buttigieg, must have appointed the chief safety officer who issued the final decision. But apparently that didn't happen. And the reason why we didn't know this is the Department of Transportation doesn't tell people who's appointed by the department head and who isn't. And they do this in secret memos, and then only present the memos when you ask. So Polyweave presumed this guy who was sitting basically as in a pretend judge's chair in their administrative proceeding was properly appointed to be an administrative judge in this capacity, and he just wasn't. And so what the agency did is they said, hey, how about we just call it a do-over? We'll vacate the penalty against Polyweave, and we'll call remand or return this decision back to the agency to prosecute or not. We actually resisted that attempt. You call this an unusual win. Yes, the agency offered to zero out the penalty against our client, and we discussed it with our client, and we decided to say, and our client agreed, and we decided to say, not so fast, Your Honor. We actually want to get to these other questions, including the double removal protection under free enterprise.
Right.
Ultimately, the court.
Let's just explain that a little bit.
Yeah.
So we have a number of issues here that were things that were done wrong to the client, and when the agency does this, they are allowed to sometimes ask for remand back to the agency when they admit they have a problem and tell you they're going to do things differently now and fix that problem, right? So the courts allow that type of remand, but there's some gamesmanship goes on here, because once you've been put through the ringer and they find you, and everybody knows they find you, and you've injured the company, you want to get it all done in one shot. You want the courts to decide all the things they did wrong at one time and not come back in the sweet by and by once they've had a chance to fix all their problems.
Yeah, precisely. And we think if the agency decides to re-prosecute against Polyweave, there's no reason to think they'll do anything differently. Ultimately, the court did dismiss the case. I think it was a close decision. So, we're still happy because the civil penalty was vacated, and I think the agency should be careful trying to re-prosecute Polyweave, because we will make the same arguments once again, and we think we will prevail because the agency's proceedings are so unreasonable.
Yeah. And and a win, as I always say, a win is a win. And the other thing is, as far as these removals and the unitary executive and who can actually penalize you in the government, it's a good outcome, because we want the various agencies to be following what the Supreme Court has told them they have to do, right? So this helps in that sort of area. And
it does. And
go on.
But I want to say it's the agency's admission that its chief safety officer was improperly appointed. It's a little surprising, because this same chief safety officer has presided over a couple dozen cases at least, and issued thousands upon thousands, if not millions of dollars of civil penalty orders in the last 4 years since Lucia was decided. When Lucia was decided, the Solicitor General went and sent a memo to every agency and said, hey, properly appoint your or properly reappoint your adjudicators based on the rules that the Supreme Court set forth. And apparently this agency just tore that memo up and ignored it. And while it's nice that the agency has vacated the penalty against our client, there's dozens of other businesses out there who paid civil penalties to the agency believing they were issued by a properly appointed adjudicator, when in fact, all along, he lacked any authority.
And that is, so this is the other thing about bringing a suit or opposing some of this stuff. If we hadn't brought this case, nobody would know this. This guy would be happily going along making adjudications.
Yeah, I know, for who knows how long.
Right.
And it's really funny. There's another one of our clients that we medical conversion that we just filed a new case, who this same guy who the agency admitted was improperly appointed issued a civil penalty order 2 days after the lawyers, the agency's lawyers, told the court that he was improperly appointed. So it just galls me that they say, well, we made a mistake here, but the same guy's still doing it.
Yeah, at some point, it's not a mistake; it's a policy. But all those other people, the administrative agency isn't under any obligation, apparently, to go tell them that all their fines were improperly adjudicated.
Yeah, well, we've reached out to some, and we've actually just reached an agreement to represent one company to attempt to recoup or get reimbursed.
Yeah, but
go ahead.
The agency doesn't have to say anything, right?
Yeah, the agency has no. I would think its duty of candor would have to reveal some of this information, but it falls upon groups like ours to go around, calling these companies up and saying, we think you were improperly fined 2 or 3 years ago.
Well, Sheng, I think we're about out of time on this, but that is an incredible story, and congratulations on your win.
Thank you, John.
Welcome back to Administrative Static. This is Mark Chenoweth with John Vecchione, and we have asked Sheng Li to stick around and talk with us in this segment as well, because he has been the lead counsel for NCLA in our representation of the Cato Institute in the lawsuit against the Biden administration over the student loan forgiveness fiasco. And that case that where we're representing Cato is stuck in the District Court of Kansas. The judge has not ruled on any of the pending motions before him. So we are going ahead and filing an amicus brief in the U.S. Supreme Court in the 2 cases that are now pending in front of the Supreme Court. So that's Biden v. State of Nebraska et al. And that et al. is I think 4 or 5 other states, including Kansas, Missouri, Arkansas, South Carolina, and Iowa. And then there's a case, a Department of Education v. Mira Brown out of the 5th Circuit. And so we're going to, so this amicus, I guess by the time this program airs, the amicus brief will have been filed, Sheng. So one of the main concerns that we had, and one of the concerns that has surfaced with really both of the cases that have come up to the Supreme Court is whether or not these plaintiffs have standing to oppose the student loan forgiveness program, the loan cancellation program, we can call it. And in particular, there was a brief filed by 2 law professors, Will Bod from the University of Chicago and Stan Bray from Notre Dame University, suggesting that even the states don't have standing to sue. So I thought maybe we could start by, if you could maybe explain why they think the states don't have standing to sue, and then we can shift to why we think there's another reason why the states do have standing to sue that that is the main subject of our amicus brief.
Sure, Mark. About 2 decades ago, the Supreme Court came up with a decision called Massachusetts v. EPA, where it determined that states have some special solicitude in standing arguments, and that allows states to have standing in many instances where normal litigants would not. And the amicus brief from Professor Brown from Bold, criticized that doctrine and say you shouldn't, there's no reason to give states this sort of special power to have standing. And in any event,
special solicitude, I think they call it sometimes.
Yeah, special solicitude, exactly. There's no, that's not in the Constitution at all. And furthermore, they argue that the state's best theory of standing is based on this Missouri agency that finances loans and or services loans, and they say that that's the wrong plaintiff for this particular lawsuit because that agency hasn't sued, only Missouri has sued. So those are sort of more kind of both the special solicitude argument and the getting an independent agency within the state as the basis of standing when the state itself is suing are both sort of circuitous ways to get to standing. We think they probably should hold up, but we tell the court in our brief, listen, Supreme Court, you don't actually need to get into these maybe, peripheral ways of getting to standing because there's a very easy way here of finding economic standing against the states, and that's through the statute that Congress passed over a decade ago called the Public Service Loan Forgiveness Program, which
Precisely.
What that does is, so that's a congressionally enacted program. Oh, go ahead, Mark.
Well, I was just going to say, so as you're saying, it's a congressionally enacted program, and that is the basis for standing that NCLA came up with, and we asserted on behalf of the Cato Institute in the pending lawsuit in Kansas. But it doesn't just work for public interest organizations like the Cato Institute. It also works for state governments because when Congress created this program, they created it to apply to both kinds of public service employers.
That's right. And what the program does is if you're a borrower and you work for what's called a qualified employer or qualified public service employer for 10 years, you can have all your entire balance of student loans forgiven. And qualified employer, as you say, it includes both 501c3 companies like Cato, but it also includes state government agencies. So, and at the end of the 10-year period, you get all your loans forgiven. And so that's a huge benefit to the employers. It's essentially a deferred compensation subsidy that makes it easier for the employers to attract college-educated employees and lowers their labor costs. But that benefit depends on the size of the loan that's ultimately forgiven. So if you forgive a sizable portion of that loan today, then the amount that's forgiven at the end of the 10-year period is going to be reduced. In fact, according to the Biden administration, it'll be zero for about 20 million borrowers, and those borrowers will have no incentive whatsoever under the loan for the congressionally enacted loan forgiveness program to work for a company like Cato or to work for a state government, and that's a very bread and butter economic harm when you take away a deferred compensation subsidy that goes to the employer and makes it harder for them to hire people, and makes it more expensive for them to keep them, to retain them.
Exactly right. So the loan cancellation program directly harms the states because it takes 20 million employees out of the potential pool for them to hire, or at least the potential pool for them to hire on this preferred basis that makes working for a state government more attractive than it would otherwise be. So that's not the only argument that we make in the brief. And go ahead if you wanted to finish off on the standing thought.
Oh, no, that's precisely right, Mark.
So there are other arguments that we make, including the fact that the HEROES Act violates Article 1 of the Constitution, particularly the vesting clause and the appropriations clause. And maybe we can get into more of this another time. But do you want to talk about either the vesting clause or the appropriations clause and how the petitioner's interpretation, that is the government's interpretation of the HEROES Act, violates one or both of those clauses?
Well, yeah, simply put, the government is interpreting the act to allow it to rewrite congressionally enacted laws. Congress enacted, laws that allow allow kind of debt to be canceled under very specific circumstances. When when a borrower is disabled or unemployed or suffering really harsh economic conditions. And the department just said, you know what, we're gonna cross those conditions out, and we'll just invent our own conditions. And that's clearly an act of legislation, which Article 1, Section 1 says all legislative powers vested in Congress and not to be exercised by the executive branch, such as the Department of Education. And the same is true for under the Appropriations Clause, which says only Congress has the power of the purse. Only no program can be funded, including debt relief programs, unless Congress appropriates some amount of money to finance that program. And here, the department just conjured money out of thin air to finance the debt relief, which is estimated to be about $500 billion to 40 million borrowers. And that's a clear exercise of Congress's exclusive power of the purse, and thus not permitted by the Constitution.
Yeah, and it also violates bicameralism and presentment, because this is rewriting the statute without going through that process, which Congress and the president normally have to go through if they want to rewrite a law.
That's right.
So this is really just an abomination of a constitutional shortcut. And no matter how President Biden and Senator Bernie Sanders want to dress it up with a map of the United States and Post-it notes. John, go ahead. I know you want to get in on this.
Because as I did post on this, and I rarely post on this, but I saw that the thing is, Sheng, this is just like if the president wanted to say, after Congress had passed a tax cut, because Bernie was very upset that Congress passed tax cuts, and he said, the Congress passed these tax cuts.
Tax cuts for the wealthy.
Exactly. So this is like that. And the thing is, the key there is that they passed them. This would be like the president saying that here's the
Congress
people he
passed
likes.
them.
He doesn't, oh no, we're not going to tax these people. If he just said, I'm not going to tax unions anymore, or
people with student loans,
or people with student loans. Exactly. It's the same thing. There's another branch with that job.
Right. And it reminds me of this argument that Philip Hamburger makes about the dispensing power, that there was this royal prerogative in pre-colonial or in colonial times where the King of England, King George III, and his predecessors could just decide not to apply the law to certain people. It was considered a kind of dispensing power. And that was absolutely something that the colonists were aware of, that they objected to, and that they did not give that sort of dispensing power to the president of the United States or to the executive branch in writing our Constitution. And Philip has written very eloquently and persuasively on this point. And if President Biden were allowed to do what he's doing, it would be an exercise of dispensing power, from what I can tell. And so, I think that that's an additional concern, not really the focus of our amicus brief, but an additional concern about what's going on here. Because if they can rewrite the statute in the way that Sheng was talking about, they can rewrite this statute, they could rewrite any statute. And at that point, you've really cut the Congress out of its role as legislator and policymaker. And here it's very clear that you're doing that because Congress already had another policy, the Public Service Loan Forgiveness Program, that had particular parameters around it, that had particular appropriations for forgiveness there, and you don't see that with the program that the president has crafted on his own, the loan cancellation program. So, Sheng, is there any other aspect of? Yeah, go ahead. We have about 30
one
seconds.
last thing is that the government made this argument in their brief that they've actually been pausing loan payments for many, many years, and no one's challenged that. Therefore, this cancellation must be legal. And we explain in our amicus that the pause was just as illegal, and in fact, the pause started okay because it was Congress created a 6-month pause, and then the federal government came in and just crossed out Congress's deadline for that debt relief program, which was September 2020, and just kept on extending it and extending and extending it. And that causes the same problem here. When you cross out one deadline and replace it with another, that's right.
Just because what you did was illegal before doesn't mean what you're doing now is okay. So two wrongs don't make a right, and we'll talk more about that issue down the road. Thanks for being with us on Administrative Static. Back with more right after this.